Hey everybody, welcome to John's Briefs. Here today again with Marc Victor from Attorneys for Freedom. And you watched the video that we had on the channel with Massad Ayoob talking about, saying nothing or what to say. And Marc watched it and he got a little hot, quite frankly. And so today we are going to have a rejoinder to Massad's video about what to say to the cops. Today's video is brought to us by Firearms Legal Protection. Firearms Legal Protection is a legal defense program for lawful gun owners with a 24/7 emergency hotline and plans designed specifically for self-defenders. They are offering a discount on their plan to Ask fans, so hit the link in the description for that. So I would like to say, Marc, thank you so much, man. I always appreciate having you on the channel. It's always good for people to get, I think, especially in areas like this, multiple inputs. So Marc, for those of you guys who don't know, a 26-year criminal defense attorney here in the state of Arizona, trial attorney, Attorneys for Freedom, a big organization here, now licensed as well in Hawaii.
Hawaii as well, yeah. We do cases nationally as well. So we have done many cases in many other states across the nation.
Nice. So you watched the video with Moss and you take umbrage.
Well, look, let me just say first off, everything I say is with great respect, right?
Sure.
I mean, obviously, we're on the same team here, and he's trying to give people good advice, but our areas are slightly different, right? I represent people in criminal cases, and he's a use of force expert, and so there are slightly different positions. And I also say it's very, very difficult to give sort of blanket general advice that applies to every situation.
Right.
I mean, this is the same.
The classic attorney, it depends, right?
And it's sad to have to say that, but it really does depend, right? I mean, is it a good shoot? Is it a bad shoot? Is it in the gray area? Are we dealing with somebody who's too stressed to talk? Are we dealing with somebody who's a good communicator? What kind of a police officer are we dealing with? Sometimes you deal with I've had officers in my career who take the position, I don't think anybody who's not a sworn officer should have a firearm. Well, if you're dealing with one of those officers, probably best to keep your big mouth shut, right?
Right.
You may have somebody who walked into a scene and has a pre-existing opinion about the situation that you're not going to talk them out of. So very, very difficult to give general advice, which is why probably the advice that is such a overwhelming majority of criminal defense lawyers, in fact, I think you'd be very, very hard pressed to find any criminal defense attorney anywhere who says anything very far from just shut up.
I've literally never seen an attorney, well, I've seen a couple, but nobody that would come and stand behind their words, say anything other than shut up.
Right, and you have to also remember, Moss is dealing with a situation that he is presuming to be a good shoot.
Yes.
We deal with situations all the time that aren't good shoots. And so, when you're out there talking to the police, protecting the evidence and this and that and saying exactly what happened and preserving witnesses, this could be a bad thing for you, right? Assuming this is actually a bad shoot.
I want you guys to know that we have not hashed this through. There's no script here. We're just having a discussion and figured you'd want in. I wonder if, Marc, if there's any truth to the idea that maybe, it used to be that the justification defense was an affirmative defense and you had to prove that it was justified. And in those cases, if that's the way it is, then I want to preserve as much evidence as possible and I want to establish a narrative in those things because I have to prove that what I did was okay, but that's not the case in the U.S. anymore.
Well, it depends. And it depends which state you're talking about, right? Here in Arizona, the state has the burden to prove beyond a reasonable doubt that it was not self-defense, which sometimes this is a good rule and sometimes it's not a good rule, right? If you think about it from a justice perspective, we people in the gun community tend to like a rule like that, right? Because it makes it easier to show a self-defense case. But just maybe a blast from the past here, right? Think about the Jodi Arias case for a moment. She, her defense lawyer could have said, look, she gave 5 different versions of events. There's no other witnesses. One of those versions was, I acted in self-defense. Can the state prove beyond a reasonable doubt that I didn't? That could have been a very good argument maybe in Jodi Arias' case, and so maybe she walks. So for people who wouldn't have liked that result, maybe this rule is not a good rule in her circumstance. So, again, this is why and it's slightly off the subject, but this is why I like things like jury nullification, right? Because it's very difficult to come up with any one rule, whether it's advice or it's a legal question, a law, that covers every circumstance. So there's always exceptions. So, all right, so let's get into some of the things that give me just a little bit of heartburn when I listen to what Moss had to say here, right?
Now, I just want to take a second, though, and recognize that the thing that I appreciated is that you said, hey, look, we're looking from a different perspective. We're seeing some things a little different. And we both have our areas and we can disagree respectfully. Good Lord, that we should have more of that in our society today.
Isn't it sad that you got to pause and make that point?
Yeah.
If you can't have a civilized disagreement, you shouldn't be part of the discussion as far as I feel about it. So, look, I have great respect for Moss. I think he does great work. I think he's been a great contributor to lawful, responsible gun owners in training and all of that. But, you know, there are some things, and look, there are other criminal defense attorneys who would disagree with some of the things that I say. That's fine. This is the nature of law. That's why we call it a practice. It's not a science.
That's right.
We're practicing here. So, you know, all right. So let me start with a couple of things. Well, Moss says you get one chance to make a good first impression. Maybe that's true, but that one chance doesn't have to be right there at the scene. You can make your first impression up there on the witness stand at your trial. And sometimes, especially in a case where you might have a novel type of a defense, like maybe I'm not the shooter, or maybe it wasn't me, I was in France at the time, or who knows? You may have something you decide you want to unveil to the prosecutor for the first time in the middle of the trial after the government has rested its case. There could be strategy reasons to sort of play those cards a little bit closer to the vest. Because remember, it would be nice if the world divided out into clearly good shoots and clearly bad shoots. But some of the videos you've sent me to discuss, one in particular that we're going to discuss maybe later today, tough call.
There's gray area ones where you're like,
There's a lot of gray area, and in those gray area cases, imagine a gray area situation with a good person. You got a good person, no priors. Maybe it's your typical, you know, I was at home and it was 2 o'clock in the morning. Maybe I had been drinking peacefully in my house, but I'm a little tipsy. Somebody comes into my house to steal my TV, and I grab the gun. And just as the guy turns to flee because he sees I got a gun, I shoot him, and now there's a shot kind of on the side. And it's one of those tough, you know, maybe good.
Got a little stink on it.
I'm not trying. My job is to be an advocate. My job is to get that person's rear end out of that situation. I'm not necessarily trying to get the just result. That's the job of the general system. My job is to work within the ethics rules to make it as hard as possible, to make the government or the state, whoever's prosecuting, dot every I, cross every T, and make sure that they carry that burden, their burden, beyond a reasonable doubt.
So this is fun, Mark, because I think this is a principled issue, okay?
Totally.
For us to talk about, because I've had somebody say, well, you know, John, as a law and order person, I said, I'm not a law and order guy. I am at my core, you know, the lowercase L libertarian idea of no, I want little government, and if the government wants to lock someone in a cage, I want them to have an incredibly high bar to do that.
Yeah, so keep in mind now, I wear two hats. Hat number one, Mark as the criminal defense attorney advocate for his client, right? So as the advocate for my client, I may or may not want my client to go out of the way to preserve evidence. The burden is not on my client or the defense to make any arguments, generally speaking. I mean, first, the government has got to prove the underlying crime, right? Because self-defense is a justification. In essence, what you're saying is, yes, I did commit that crime,
but
and now I can prove that I acted in self-defense, or they can't prove that I didn't act in self-defense. But the first step is the state or the government, whichever, or the people, depending on which state you're in, they got to prove the underlying crime. And as an advocate, my job is to prevent them from doing that. That's not to reach a just result. The Mark as a citizen, the citizen hat, what I would say as a citizen, look, I want a just result.
Sure.
How do we get a just result? We get a just result by having two advocates. in an adversarial system with different missions, right?
Right.
And so we have slightly different goals. So when Mas is commenting on this, I think he's more wearing a citizen's hat. When I'm commenting on this in this type of a video, I've got an advocate hat on. I'm thinking, how do I protect my client, whether he was in the right, whether he was in the wrong, or whether we're in a gray area? People don't hire me to get them justice. They hire me to put the government to its burden of proof. And if they can't make it, and taking my advocate's hat on, putting my citizen's hat on for a moment, we as citizens care more. We're more worried about an innocent person getting convicted than we are 10 really guilty people going free.
That's an underlying foundation of the justice system that we've adopted.
Yeah, that's why in theory we are to skew, the thing is skewed. It's supposed to be beyond a reasonable doubt, right? It's the reason why there are certain protections for a defendant in a criminal case. That's the reason why when Mas says, hey, you know, if you don't say this or that, there's 2 perps out there that you didn't tell the police about. That's why the prosecutor is not going to be standing in front of that jury and saying, hey, this guy should have told, in essence, commenting on the right to remain silent in front of the jury. That's not a concern. That's not going to happen. We don't have to worry about that because uniformly across our nation, prosecutors in a criminal case, and of course there are a few sort of nibbling factual circumstances that are extreme around the edges, but generally speaking, 99% of the time, the state doesn't get to comment on the fact that the defendant or the person who was under investigation at the time said nothing.
Right.
They don't get to make an issue because you have a right to remain silent. And because of that right, the jury is going to get an instruction that specifically tells them you don't get to make any negative inferences at all about the fact that the defendant remained silent. So you got to keep that in mind, you know, from an advocate's criminal defense attorney perspective. I'm not worried about that issue at all. That's remaining silent is always the better course. So
it's definitely the safer course because if you say something wrong, it can and will be used against you.
Absolutely, there's no question about that.
But if you say nothing, it cannot be used against you.
You may say something, the right thing, and it may be misconstrued by the officer.
Yeah.
It may be written down wrong. It may be recorded wrong. You may get a bad officer who intentionally writes down wrong what you said. Do you really want to trust your freedom to that? I don't. If you keep your big mouth shut, then you don't get across, you're not in that area where you're now relying on someone else to record it. It's great. If they're videotaping it, great. But they're not. You rely on what they're writing down in that little notebook to later summarize in the police report. And guess what? The officer's going to testify, this is what you said. Even if you say, no, I never said that. Guess who the jury is going to believe? So just moving along. I understand. And by the way, let me just back up a little bit and say, I can absolutely imagine a set of circumstances where everything Mas says is the right thing to do. It depends, right? And we're talking about
lawyer. It depends.
It depends. If you're in a good shoot, and it's clearly a good shoot, and you got someone who's a good communicator, and you got an officer who's being accurate, and there actually is evidence that needs to be preserved, and there are witnesses who are standing around, absolutely, what he says is entirely correct. But you don't know that at the time. At the time, you're not even thinking like that. If anybody who's been involved in a shooting knows, this is a terrible time to be trying to make a statement that's going to be a recorded statement that's going to be used against you a year or maybe 2 years down the road. It's just not a good idea. So sometimes the person who calls first is charged with the crime. I've seen this on many occasions.
Really?
Happens in the domestic violence context all the time. There's a fight between boyfriend and girlfriend, husband and wife. One calls the police, that person comes down, the police come down, they speak to that person, they get both sides, and then you know what? The person who called is the person who gets arrested. I've seen it on many occasions. I've been on many times sitting in this very office saying, isn't it interesting? You actually wound up calling the police on yourself and you got arrested and taken away and now you're the one charged. Yeah, that's how it went down. So it's not just a matter of who called first. The police are sophisticated enough, and you can bet that the prosecutor, who's the one who's actually making the decision here, especially in a shooting case, is definitely sophisticated enough to say, I'm not going to be swayed just because this person called for. It's not lost on them that we sometimes think, we sort of, people in the world think, oh, if I'm the race to call, if I win the race to call first, they might think that I'm the good guy. They know that. This isn't rocket science to them. So I'm not overly impressed. And the other thing is, you know, Moss talks a lot about making a good impression on the police officer. Absolutely. I'd rather have a good impression made on the police officer if possible.
Sure.
But the police officers, if they're good officers, aren't going to think anything negative about somebody keeping their mouth shut. Why? Because that's what they're going to do themselves. That's what they're taught. If you're in a shooting, guess what FOP, the Fraternal Order of Police, is going to tell them? Shut up.
Every badge cam that we have on the channel, you get an officer involved shooting, their sergeant rolls up, you know, whatever. They will maybe start talking, but you'll hear their sergeant, you turn your badge cam off, go sit in your patrol cruiser and shut up. They'll tell them.
Good police officers understand that the smart thing to do is to not make a statement.